Hearing in the appeal, the Secretary of State for Justice and MM.
Mr. Atkins,
Lady.
it is a delight to welcome you to this court, although the reason why we are welcoming you is not such a delight. One of these days, of course, we may welcome you here as counsel in a case, but today we welcome you in your immediate past capacity as leader of the Midland Circuit. And that is because it is a very special day for this court and for the circuit. This is the last day on which Lord Hughes will sit as a Justice of the Supreme Court of the United Kingdom. He didn't want a formal valedictory, but we didn't want this moment to pass without some small recognition of all that he's done for the court and for the law. He may not see himself as a diversity champion, but in many ways he was. When he joined the court in 2013, he was the first judge from England and Wales for decades who had graduated from a university other than Oxford or Cambridge. He was the first for decades whose success at the bar had been established outside London on the Midland Circuit. He was the first for decades whose success at the bar had been based on a largely criminal practice. And he had started his full-time judicial life in that most unfashionable of places, the family division of the High Court, where he spent 6 years before transferring to the Queen's Bench and to the Court of Appeal, where he ended up as Deputy Head of Criminal Justice. After the Lord Chief Justice, who had far too much else to do, so he was de facto in charge. It was his expertise in criminal cases which brought him here. There was the inexplicable view that, despite the fact that this court contained the former Lord Chief Justice of England and Wales, the former Lord Chief Justice of Northern Ireland, and the former Lord President of Scotland, we didn't know enough about the criminal law and the criminal justice system and how it worked in the real world. Now, I could not possibly admit that that was true. However, we did gain an enormous amount by having Lord Hughes join us, and since he has been with us, we have had a very real and close understanding of the criminal justice system and the values which it is there to protect, coupled with how it all works in the real world. And the best example of that is the judgment in the Jogi case on parasitic accessory liability. But another wonderful example, of course, is the judgment in the card shopping case of Ivy and Genting, which set the law of dishonesty back where it ought always to have been. Both of these cases restored the law to a principled position from which pragmatism and hard cases had diverted it. But that isn't all that Lord Hughes has done for us. He's produced high-quality judgments in a great many fields, and he's produced a great many judgments. 71 out of the 270 cases in which he has sat means that he's written the lead judgment in many more than the 1/5 which might be expected as a fair proportion of the lead judgment writing. And he has always and without complaint agreed to take on work when asked to do so. Witness today. He wasn't originally listed to sit, but when told that there was a need because another justice was in difficulties, he unhesitatingly stepped up to the plate and without asking why. And this is what has given us the opportunity to celebrate his contribution to the work of this court and to the Judicial Committee of the Privy Council. We shall miss him sorely and wish him a long and happy future in the next phase of his illustrious career. Mr. Atkins.
My lady, my Lord Hughes of Ombersley has been a considerable presence during my career at the bar. It was he who telephoned my parents back in 1989 to invite me to attend at one Fountain Court in Birmingham for a pupillage interview and ultimately offered me pupillage. Thankfully, though, that error of judgment has not held him back. He led me on a number of occasions and was my head of chambers. He took silk in 1990, not because he'd been desperate to apply for years, but because he was told to apply by Mr. Justice Michael Turner, who had recognised something that the Midland Circuit had known for a long time. Tony Hughes was something special. It had been said during his pupillage that young Hughes would go far in this profession. He did not disappoint. For 7 years, he was one of the two go-to silks in the Midlands, the other being his friend and fellow member of Chambers, David Krigman, Queen's Counsel. Anthony's reputation as the demolisher of handwriting and ESDA test experts, amongst other things, was legendary, and a good number of police officers have a great deal to thank him for. In 1991, he was asked by Malcolm Morse, another stalwart of the Birmingham Bar, to lead him in the House of Lords in the similar fact case of P. He told Malcolm that he would explain why the case of Boardman was wrong and needed reinterpreting, whilst Malcolm could tell their lordships what they should put in its place. The two-pronged approach worked brilliantly. No longer could the criminal hack refer to the ceremonial headdresses of Red Indian chiefs or lipstick messages on the mirror. It was but a taste of things to come, Hughes rewriting the criminal law. In subsequent cases in the Court of Appeal, it was often remarked upon that it was only when Hughes, Queen's Counsel, stood up that the judges picked up their pens. Whilst in silk, he represented the first defendant in a 14-handed murder case. His client was first on the indictment. After his cross-examination of the principal prosecution eyewitness, he was given a standing ovation by all counsel on his return to the Birmingham robing room, something that had never happened before or since. It was no surprise when he was appointed to the High Court in 1997. The surprise was that it was to the Family Division. But, having read all of the leading books on family law over the weekend before his appointment, he took the Family Division by storm, and they were sad to lose him when he moved to the Queen's Bench Division. Promotion to the Court of Appeal inevitably followed, where, amongst other things, he almost single-handedly made the law on hearsay understandable to we lesser mortals and explained how we really should have been applying the Proceeds of Crime Act over the years. His secondment to the Supreme Court for the Proceeds of Crime Act case of Weyer, while still the Vice President of the Court of Appeal Criminal Division, told us all what we had long suspected, that he was still going places. And once here, as you, my lady, have mentioned, he's continued to sort out the criminal law, correcting with the late Lord Toulson the joint enterprise wrong turn in Jogi, and, sadly for me, rewriting the law in relation to dishonesty in the recent Genting casino case, when he consigned to the waste bin of history one of the few cases I still remember from bar school, gosh. And throughout all of this, he has continued to ring bells at his local church, to row for Worcester Boat Club, to windsurf in Cornwall, and, when the hip became a little too troublesome, to have some work done by Lord Justice Coleman Tracy's eminent surgeon brother. Yes, it isn't just a rumour. They really have rebuilt him. He's our own Midland Circuit bionic man. He's also a devoted family man. And I'm told that when his marriage was announced to Lady Hughes, that her family were particularly delighted, as they felt she had finally found somebody who was almost as intelligent as she is. My lady, in sum, the weight of the job takes its toll. I, for example, find myself fighting every day with a grey-haired old man who now seems to inhabit my shaving mirror. Lord Hughes, though, seems to have taken everything in his stride and has not aged one jot in the 30 years that I have known him. Some say he must have a picture in the attic. I think it must be a complete gallery. My lady, it is a tradition on the Midland Circuit that when a retiring judge is given a valedictory, that a story or two at the judge's expense should be told. My lady, during my time as Midland Circuit leader, I kept a little black book. I can tell you, though, that Lord Hughes, or Teflon Tony, as he was not known, never ever featured. The best I have been able to unearth are these two stories. The first is when he played for the Chambers cricket team in the early 1990s. He turned up in immaculate cricket whites and strode out looking every inch the 1950s England cricket captain. He took up his position at the crease and was promptly bowled first ball. He put his bat back under his arm and strode back to the pavilion as if he'd just scored a century, and the game was never spoken of again. It is an approach I have adopted on a number of occasions in court when I have effectively been bowled first ball. I also appeared before him as the prosecution junior in a murder case in Worcester. One day, I was summoned together with the defence junior to see him in chambers. He told us that we would be sitting early the next day. When I sought to persuade him to sit later rather than earlier, as we had witness difficulties, I was told very firmly that we would be sitting at 9:30 the next day. So we did. And as I had predicted, we ran out of witnesses and had to rise. Shortly after we had risen, the then Lord Chancellor, Lord Irvine, arrived on an unannounced visit. If only Mr. Justice Hughes had listened to me, we would have been in full swing rather than twiddling our thumbs. I've often wondered if that blighted his career in some way and held him back over the years. My lady, I would like to thank Lord Hughes for giving me this pain-free opportunity to address the Supreme Court, something I have hitherto strenuously avoided. But more importantly, I should like to thank him on behalf of the Midland Circuit and the Bar as a whole for all he has done for our profession. He was a fabulous barrister and has been an absolutely wonderful judge. May I wish him a long and happy retirement with Lady Sue. We shall all miss him, but we know that the Supreme Court's loss is the Inner Temple's gain, and I look forward to working with him next year when he is Treasurer of the Inner Temple and I am Chair of the Bar.
Thank you very much, Mr. Atkins.
Hale. When I first started as a barrister at 2 Fountain Court in Birmingham, 1987, there were a series of hugely impressive and frankly some rather daunting characters at the Birmingham Bar. But the head of chambers of next door chambers, number 1 Fountain Court, was the perfect role model for any aspiring barrister. Tony Hughes appeared to us to be effortlessly brilliant. I'm sure there was an awful lot of unseen effort. But he was a common law practitioner whose practice spanned crime and a number of other areas, with a stellar reputation. But what I most recall is his kindness to those young barristers who were trying to make their way. His gentle sense of humour. He showed us how the job should be done properly and with a human face. It was a huge loss for the Birmingham Bar, but a huge gain for the judiciary when he was appointed in 1997. We both left the Birmingham Bar at the same year. Him to an immensely successful judicial career, just as I was commencing an immensely unsuccessful parliamentary career. There is no doubt who the clients of the Birmingham Bar missed most. But as a judge, my experience has been that he's unfailingly courteous, measured, and judicial, but also has never lost that gentle sense of humour. He's the antithesis of a judge with judgeitis, both on and off the bench. We both live in that rather beautiful corner of North Worcestershire, so our paths cross occasionally on the train or even on the towpath. He's always approachable off the bench, with an amusing sigh about the workload needed to do the job properly. But it's a job that he has done more than properly, and the public and the legal professionals, my learned friend, should be enormously grateful for the commitment he's given to getting the right answer in the most difficult of cases. I hope he appreciates how much he is appreciated. I also hope he'll have more time for gardening, mechanics, and campanology, the quintessentially English pastime of ringing bells without generating a tune, never understood by the Belgians. We wish him a long, fascinating, and productive retirement.
Thank you, Mr. Locke. Sir James.
My Lord, I'd like to make it absolutely clear that what I'm about to say is entirely dependent on and subject to your Lordship's behaviour in the next 4 or 5 hours. Subject to that, can I add my very best wishes and regrets as you move on to other fields. You have served as a judge with the deepest distinction, as a legal all-rounder, the Sir Gareth Sobers of the judicial world, family law, Vice President of the Court of Appeal Criminal Division, and now in the Supreme Court in particular, showing a clear and strong grasp of public law, European Convention on Human Rights law. Your judgments and interventions in court, if I may be so bold, have all illustrated that prime judicial quality of robust good sense and the ability to make the complex readily intelligible to those with smaller brains. It is no accident, perhaps, that there have been a number of occasions in this court where the court has split 3-2, and it is to your judgment that we turn as the casting vote. I can think of a sequence of judgments that could truly be described as great. The Prince Charles Letters judgment, the judgment that my Lord gave in Gina Miller and whoever happened to have been the Secretary of State for exiting the European Union at that particular moment in time. Those 2 judgments destined perhaps to echo Lord Atkin and Liversidge and Anderson as having their greatness only recognised years after they were given, both of them having been dissenting judgments. I personally will miss the judicial tells at this poker game in which I am a bit part player, the pursed lips, the wry smile, don't be fooled at that stage, and then the killer blow delivered with a half chuckle. My Lord, we wish you the very best as you head back to bell ringing on ground made holy by Abbot and then later Saint Egwin.
Thank you, Sir James. Thank you.
Well, thank you all very much. For a criminal hack, it's a great comfort to see that the hallowed tradition of giving the accused notice of the charge against him has been observed so carefully. All I can say is that we're very spoiled here. We're spoiled by the way we're looked after behind the scenes, but we're immensely spoiled by the advocacy. And you almost forget what went before. I've been spoiled by advocates all my life, and it's a huge pleasure to see three very powerful ones here today, and I'm very grateful for those who've come specially. It's been a lot of fun. I've thoroughly enjoyed it, and it's time to do something else, and I shall look forward to it. Thank you very much indeed.
Thank you. Thank you. Now, I believe we've got a case to hear. And I should remind everybody that there is a reporting restriction order in this case, which I'll read out just to remind everybody. The court ordered that no one shall publish or reveal the name or address of the appellant who's the subject of these proceedings, or publish or reveal any information which would be likely to lead to the identification of the appellant or of any member of his family in connection with these proceedings. I always read that out when we have such an order because, of course, the proceedings are being live streamed and it's extremely easy to forget unless we've all been reminded, and that applies to everybody who might open their mouths in the course of these proceedings. Yes, Mr. Locke.
My ladies, my lords, I appear with my learned friend Mr. Blundell for the appellant, assisted by my learned friends Mr. Paget and Ms. Whittingham, who represented the appellant in the Court of Appeal. My learned friends Sir James Eadie and Mr. Lowe appear for the Secretary of State, who is the respondent. Lady, this case is primarily, we submit, about statutory construction. The key question for the court is whether the power of the first-tier tribunal under Section 73(2) of the Mental Health Act 1983 to set conditions as part of a conditional discharge for a restricted mental health patient who's detained in hospital, either A, provides the tribunal with a general power to set such conditions as it considers appropriate in the circumstances of the case, essentially that's my case, or B, is a power which is subject to an implied limitation in that the cumulative effects of the imposed conditions cannot amount to an objective deprivation of liberty of the mental health patient. And broadly, that's my learned friend's case. Now, the case has a number of unusual features. The primary unusual feature is that the limitation contended for by the Secretary of State is a limitation which is said to be necessary to ensure there is no breach of the human rights of the mental health patient. However, it's the patient's case, there is no such limitation. So the first unusual feature is the Secretary of State is seeking to use the protection of the patient's human rights as a reason to limit the powers of the tribunal to remove the possibility of the tribunal delivering the precise outcome that the patient seeks. The second unusual feature of the case is the consequence of the Secretary of State's argument is that conditional discharge orders will and are not being made by the tribunal in cases where if the power was wider, they could be made. Consequently, the effect of the limitation is the patient remains detained in hospital unless the Secretary of State agrees to the patient being granted leave to reside in the community under Section 17 of the Mental Health Act. Thus, in practice, the effect of the limitation is to remove decision-making from the tribunal and vest it back with the Secretary of State, reverting to the same position prior to the amendment made to the statutory scheme as the result of X in the UK, which then led to the Mental Health Amendment Act 1982. The 1982 Act, as your Lordship may recall, made substantial changes to the Mental Health Act 1959, and then in 1983, a Consolidated Act was introduced. So the Mental Health Act 1983 that we now have is a Consolidated Act, substantially bringing the 1959 Act up to date in accordance with the 1982 Act. So I propose to structure my submissions in the following way. There have been four parts. Firstly, to say a few words about the underlying facts and the history of the litigation. Secondly, to make submissions about how the Tribunal's powers fit into the wider statutory scheme of the Mental Health Act. Thirdly, to make submissions on a common law interpretation of Section 73. And then fourthly, to make submissions to the extent which human rights considerations impact on the statutory construction exercise for Section 73. So firstly, the facts and the litigation history. The primary facts are set out at paragraph 3 of the decision of the Court of Appeal, which is MS 116. More details of the facts appear in the Tribunal decision, but the Tribunal identified two main areas of serious risk for this individual, who I shall refer to as MM. One is a risk of fire setting, and secondly, a risk to women as a result of MM's misunderstanding of the nature of interactions with women. MM's compliance with medication has not been reliable or consistent, and no significant progress was made in his rehabilitation programme in the 4 years between 2010 and 2014, when the Tribunal first heard the case. This case therefore came before the Tribunal in circumstances where everybody accepted a change of environment would be beneficial. But the competing contentions were that his treating clinicians recommended a move to either a locked rehabilitation unit or a low secure service, and the external clinical experts instructed by the patient's lawyers recommended that he could be safely managed in the community under a conditional discharge, provided he was subject to appropriate restrictive conditions. And the Tribunal's conclusion is at page 51 of the core bundle, MS 162, that a deferred conditional discharge containing the single condition compliance with the plan devised by Mr. Lawson, who was the external expert, would not be a lawful order of the Tribunal. And they reached that decision because compliance with the condition of the plan, which provided for residence and no unescorted leave, would amount to a deprivation of liberty. And there's no dispute in this case that compliance with the plan, namely living in essentially a locked hostel and only having leave escorted by a member of staff, would amount to a deprivation of his liberty. I should also draw the Court's attention to the observation at the bottom of that page 51, MS 162, which concluded that MM's propensity for changing his mind meant that he was unable to give, in the view of the Tribunal, a true and unfettered consent to any terms of a proposed conditional discharge. And thus any consent he gave would not be a genuine, properly considered and reliable consent. MM appealed to the upper tribunal, where the case was considered by Mr. Justice Charles, and that's at MS 135 in the appendix. Mr. Justice Charles criticised the decision of the tribunal on the issue of consent at paragraph 29. I'm taking this at some speed. I hope that's acceptable to your ladyship and your lordships.
We'll tell you if it isn't.
I'm grateful.
It's okay so far.
The appeal was therefore conducted on the basis that that part of the tribunal's decision was wrong, and MM did have the capacity to consent. There was no further appeal on that point, and thus for present purposes the court is invited to assume that it's ruling on the case of a patient who has the ability to give valid consent, but also bearing in mind that the possibility that any consent thus given may be withdrawn by the patient at a later date. And the Secretary of State's appeal to the Court of Appeal was allowed at MS 112, and the essential reasoning of the Court of Appeal, which we'll come to later, but for purposes I summarise at the moment, was that A, the powers of the tribunal did not extend to imposing conditions which had the effect of depriving a mental health patient of his liberty in a community placement. That's paragraph 18 of the judgment at MS 120. And that B, there was no scope for consent in a case such as this. And that conclusion is at paragraph 29, MS 122. With that brief introduction, can I next turn to the statutory scheme? The statutory scheme is partly set out in our case and partly set out in the respondent's case, so I hope I can take this reasonably swiftly. A detained mental health patient can broadly have one of three statuses under the Mental Health Act. Firstly, the patient can be detained pursuant to a decision made by an approved decision maker under the Act, either on a short-term basis or on a longer-term basis. Secondly, the patient can be conditionally discharged, in which case the authority to detain the patient at the named hospital pursuant to the Act remains in effect because the patient remains liable to be recalled to detention by the Secretary of State at any time, and that category only applies to restricted patients. And the third status is the patient is absolutely discharged from detention, in which case he or she can only be re-detained after the following of a fresh decision-making process under the Mental Health Act. Now, there are a number of different routes by which a patient can find themselves compulsorily detained under the Mental Health Act. These range from urgent detention by a constable to a place of safety under Section 136, admission and detention to hospital for assessment for up to 28 days under Section 2, admission to a named hospital on the written application of 2 doctors and detention for treatment under Section 3, and that, for many patients, that is the long-term basis upon which they are detained when they're admitted for treatment. Where a hospital order is made by the Crown Court under Section 37 or Section 45A following a criminal conviction. And finally, where a Secretary of State directs that a prisoner is suffering from mental health and orders the transfer of the prisoner from the prison estate to the mental health estate under Section 47. Those are the various routes by which people can end up being detained mental health patients. A restriction order can be made in the relatively small category of cases where the mental health patient represents substantial risks to the public. Where no restriction order is in place, decision-making for patients under the Mental Health Act is entirely vested in a combination of the responsible clinician, the RC, the hospital managers and the tribunal. But where there is a restriction order, the Secretary of State is given a role to act in the public interest, and such an order can be made by the Crown Court when making a hospital order under Section 37, or by the Secretary of State under Section 49, where a prisoner is transferred to mental health detention. And the broad effect of a restriction order is that the Secretary of State is given a range of powers to exercise in the public interest in relation to the patient for which he is politically and legally accountable. And in particular, the RC cannot approve leave of absence under Section 17 without the consent of the Secretary of State. The RC cannot transfer the patient to a different hospital without the consent. That's Section 41. If the patient is given leave of absence with the consent of the Secretary of State, the Secretary of State can withdraw that leave of absence, and the powers of the responsible clinician and hospital managers to discharge under Section 23 are removed, and therefore discharge is only with the consent of the Secretary of State or by the tribunal. But of course, the Secretary of State has the power to lift the restriction order at any time, Section 42, and crucially for present purposes, Section 42(3), Secretary of State has the power to recall a patient who's been conditionally discharged. The Secretary of State also has a power to, where a patient has been conditionally discharged, the Secretary of State has the power to impose additional conditions in the same way as the tribunal can. The discharge of patients under the mental health scheme is by the tribunal is primarily governed by Section 72 and 73. Section 72 provides a duty on the tribunal to direct the discharge of the patient if the detention criteria do not continue to be met. And the detention criteria are set out in the respondent's case, and I won't take you to them because they're not relevant for today's purposes, but they are the criteria that have to be met. And if any of those criteria are not met, then Section 72 provides for the patient to be discharged. The tribunal has a power to make a recommendation that the RC should impose a community treatment order, but the final decision whether to impose a community treatment order is for the responsible clinician, and there is no power in respect of an unrestricted patient to impose a conditional discharge. So the concept of conditional discharge is purely for restrictive patients. The power of the tribunal to order the discharge of a restricted patient is under section 73. This provides that a tribunal is under a statutory duty to direct the absolute discharge if two matters are satisfied. Firstly, that none of the detention criteria are satisfied, or any of the detention criteria are not satisfied, I should say. And they are...
Which, Mr. Logg?
It's if any of the detention criteria are not satisfied, the tribunal has a duty to discharge.
All the criteria have to be satisfied.
All the criteria have to
withhold
be
the
met.
absolute discharge.
My Lord is perfectly right. My language was loose.
No, that's all right.
And they are under section 72B1, that he's then suffering from mental disorder or from a mental disorder of a nature or degree which makes it appropriate for him to be liable to be detained at a hospital medical treatment. 72B Roman 2, that it's necessary for the health or safety of the patient or the protection of other persons, he should receive such treatment. 72B 2A, that appropriate medical treatment is available for him. And then for restrictive patients, there is an additional criteria that the tribunal is satisfied that it's not appropriate, the patient remains liable to be recalled for hospital for further treatment. That covers substantially the case where a patient at present can be managed safely in the community, but the history indicates that there are risk factors to the patient, or realistically more to the public, which means that a relapse of a mental health condition may affect the risk profile and therefore may lead to the patient having to be re-detained in hospital in order to properly manage the risk presented by an enduring mental health problem. Thus, the tribunal has a statutory duty to order the discharge of a restricted patient if any of the detention criteria are not met, and it is satisfied that it's not appropriate for the patient to remain liable to be recalled to hospital for further treatment. In that event, the decision is made to absolutely discharge him. But if the tribunal are satisfied that the detention, that it is appropriate for the patient to be liable to be recalled to the hospital for further treatment, the tribunal is then under a statutory duty to direct the conditional discharge of the patient. And in such case, the patient remains liable to be recalled to hospital by the Secretary of State, and that's section 73(4) Roman 1, and the patient comes under a statutory duty to comply with the conditions imposed by the tribunal or any subsequent conditions imposed by the Secretary of State, albeit there is no sanction for non-compliance with the duty. And the conditions imposed by the tribunal can be added to or subtracted from by the Secretary of State, section 73(5), and if the restriction order is annulled by the Secretary of State under section 42(1), the patient is then deemed to be absolutely discharged. The tribunal can delay discharge whilst arrangements are made to give effect to a conditional discharge. See section 73(7). The statutory purpose of the powers to order a conditional discharge were explained by Lord Bingham in the H and Secretary of State case, which, if I can take your Lordship and Ladyships to it, is Volume 1, Tab 4, MS 293. And for present purposes, I only need to take the court to paragraph 26 at page 277, MS 317, if the numbers are working correctly. And can I invite members of the court, if they'd be kind enough, to read paragraph 26 to yourself?
317, you say?
317, lady. I invite the court to extract from this that the statutory purpose is to ensure that the only persons who remain compulsorily detained in hospital are the hard core, to quote Lord Bingham, of those who cannot be effectively treated and supervised otherwise than in a hospital. And of course, we submit that the limitation the Secretary of State invites the court to impose on the powers of the tribunal to discharge patients under conditions cuts across that statutory purpose, because by definition, it envisages a cohort of patients who, with the right restrictions, could be managed properly in the community, albeit at a lower level of deprivation of liberty, but who, because of the proposed limitation to the general power under Section 73 of the conditions, those conditions can't be imposed, and therefore, in practice, the tribunal only has the option of keeping them detained in hospital. Further, the fact that the patient remains under a restriction order is a relevant factor in considering whether the patient continues to be deprived of their liberty under Article 5. This factor makes it more likely that other imposed conditions will collectively amount to an objective deprivation of liberty. And this was established in the Ashingdane case, which is at tab 10 of volume 1, MS 444.
Sorry, 444.
I'm sorry, it's not tab 10, it's tab 9, I apologise, tab 9, MS 444. I appreciate that some members of the court may be familiar with this case, but the facts, if I can just very shortly summarise the facts, this case arose for Mr. Ashingdane, who was detained under Section 3 and was a restrictive patient in Broadmoor. In fact, I think he may have been under Section 37, or what is now Section 37.
Sorry, he's a restricted patient.
He's a restricted patient. And he was detained in Broadmoor, and arrangements were made for him to be transferred from Broadmoor to Oakwood Hospital near Maidstone, where he, near to his home. And if the transfer had been effected, he would live in conditions of considerably less restriction. Unfortunately, the transfer was delayed for 2 years because there was an industrial dispute between 1978 and 1980 with the COSI union saying they weren't properly staffed to accept restricted patients being transferred to Oakwood. Accordingly, his transfer was delayed. He eventually went to Oakwood in 1980 and then remained there until the hearing of the case. And if the court would be kind enough to turn to 452, and there's a paragraph at the top of the page which illustrates the lower degree and progressively lowering degree of detention that he experienced at Oakwood once he finally arrived. The essential claim was for damages for unlawful, for breach of Article 5 on the basis he should have been transferred earlier. And can I invite the court to read yourself the paragraph at the top of page 536, MS 452, which explains the nature of the regime that he had at Oakwood.
Well, progressively more and more freedom.
Precisely, my lady. But the court then decided that even though he had substantial freedom, nonetheless, because he was subject to a continuing restriction order, his liberty continued to be deprived of his liberty, notwithstanding the considerable freedom. And we see that at paragraph 42, starting at MS 457. And if I can invite the court, if you'd be kind enough to read that paragraph. And the reference in particular I invite you to pick up is the reference to the restriction order, second subparagraph from the end. That clearly was a factor which the court took into account in there being a continuing deprivation of liberty. And that's consistent with the observations of Baroness Hale and Lord Sumption in Cheshire West, which I won't take the court to at the moment, but I will have to take the court to a bit later, where it's said at paragraph 21 of that judgment that a compulsory detained patient is deprived of his liberty in hospital where he is detained, irrespective of the openness or otherwise of the conditions there. So how does this apply to a conditionally discharged patient who remains under a restriction order? Well, we don't suggest that such a patient will always be deprived of his liberty or continue to be deprived of his liberty because of the existence of the power of recall. However, the logical conclusion of Ashingdane and Cheshire West is that the sword of Damocles of being recalled that hangs over a conditionally discharged patient is a substantial factor which both affects his behaviour and tends towards a finding of deprivation of liberty. It must therefore follow that the threshold for other factors, such as the imposition of restrictive conditions, where you should live, whether you should have leave or unescorted leave, which also restrict liberty, that threshold is lower before the patient is needing to cross the line, so the regime amounts to deprivation of his liberty. And therefore the effect of a conditional discharge is to give the patient back a measure of liberty. But if the Secretary of State is right, and bearing in mind the significance of the restriction order as explained in Ashingdane, the Tribunal has to give back a very, very considerable freedoms to the patient before the patient can move from a situation of having their liberty deprived, which of course they are in a hospital where they are detained, into a community placement where their liberty is no longer confined.
When you say no longer confined, no longer deprived, I mean, the distinction surely needs to be drawn between restrictions on liberty and deprivation of liberty, does it not?
Indeed, my Lord, it does. And there will be some restrictions on liberty for a patient who is conditionally discharged and living in the community.
But your submission is that that doesn't, or at least doesn't necessarily constitute deprivation of liberty.
It doesn't necessarily, but the fact that the patient lives under the constant threat of recall, observation, if you step out of line you may be recalled, is of itself a factor tending to support, is a substantial restriction.
Yeah.
Therefore, the additional restrictions that need to be placed before you cross the line are less than they would be in a patient who is not subject to that power of recall.
You're saying, well, maybe, have I got it right or not? You're saying that in a large number of cases, a conditional discharge is likely to involve the deprivation of liberty, particularly bearing in mind that all of them will remain liable to recall.
My Lord, precisely, because it doesn't take very many additional restrictions when you add in the power and the effect of a power of recall to result in the patient being deprived of their liberty. Where the patient is not recalled to hospital, Section 75(2), and didn't take you to, but can if needed, provides that he may apply to have his tribunal conditions reconsidered, first of all between 12 and 24 months after the order is made, and then thereafter within each 2-year bracket.
We do need to look at that, don't we? Because it's one of the things that the Court of Appeal relied on.
Certainly, my Lord. Well, it's tab 1, section 75 is at page 230, MS 230. I'm afraid there aren't internal page numbers within tab 1.
75.
75(2), and A provides for the initial period for reconsideration of the conditions, and B, in any subsequent period of 2 years. So, assuming one starts with a patient where the order is made in January 2018, he has the right to apply to the tribunal at any time between January 2019 to January 2020, and then once that hearing has happened, conditions kept or varied, he then has the opportunity to do so January 2020 to 2022, that 2-year window. He has one opportunity and then subsequent 2-year windows. And of course, as your Lordship rightly says, that's a factor the Court of Appeal took into account, and that contrasts with the position under Section 70 in respect of a patient who is, I'm afraid Section 70 is at MS 223.
I'm sorry I have to be slow, Mr. Locke. Do we contrast it initially with 75.1, which in turn takes you to 70? Because if you've been recalled to hospital...
Got to be referred to the tribunal.
Yes, if you're, my Lord is right.
Time limits are different, aren't they?
Yes, if you're recalled to hospital, there's then an urgent hearing. It's referred within a month.
Yeah, and thereafter, Section 70, which
thereafter,
is
Section 70.
6 to 12 months, isn't it?
Yes, well, my Lord, Section 70 is MS 223. It's earlier in the bundle, the same tab. It refers to a restricted patient within the meaning of Section 79 and is detained in hospital may apply initially between 6 months and 12 months, and then each subsequent period 12 months.
Basically, for a recalled patient, you've got an urgent reference
Yes.
within a short time of the recall, and thereafter you're subject to the same tribunal application regime as you were before.
Exactly. And
Which is something up to 12 months. Between 6 and 12, so something up to 12 months.
Yes.
It must be heard within 12 months, effectively. And 12 months thereafter.
That's right, my Lord. And so the time periods are doubled for community discharge, conditional discharge patients in comparison to patients who are in a more acute detention in the hospital. And the origin of the requirement under Article 5 to have reviews arises from the winter work case, which, if I can take your ladyships to it, is in volume 4 at tab 41. MS 1716. I can take the court to paragraph 55, towards the end of that paragraph.
Sorry, paragraph?
Paragraph 55, my Lord.
Thank you very much.
Where the court said, the very nature of the deprivation of liberty under consideration would appear to require a review of lawfulness to be available at reasonable intervals. And the intervals for the review of a deprivation of liberty within a community placement are therefore set at 2 years, as opposed to 1 year. And we submit that within the broad discretion available to contracting states to devise their own regime, a 2-year period is a reasonable interval given 2 factors. Firstly, the fact that if the patient is recalled, they will get a very prompt hearing. So the change of circumstance, you get a prompt hearing. And secondly, the Secretary of State has a power to vary the conditions at any time, and thus a refusal to vary within the 2-year period if it was clear, if that was an unreasonable variation, could be subject to a challenge by way of judicial review.
What, if I've understood it correctly, what was bothering the Court of Appeal was that as between the patient who remains in hospital or has been recalled on the one hand,
Yes,
who gets basically an annual review,
yes,
and the patient who has been conditionally discharged but yet may have terms which amount to a deprivation of liberty, he has to wait twice as long.
yes.
Well, now, do you want to say anything about that?
Well, my Lord, what I would say about that is two things. First of all, inasmuch as the patient is consenting, part of the regime they're consenting to is a regime under which they will have a less frequent opportunity to have their conditions reviewed. But secondly, if one posits that this is a regime which is moving from a higher level of restriction on the life of a patient to a lower level of restriction on a patient in a community setting, it is entirely understandable, sensible and reasonable for those restrictions to be reviewed at a less frequent level, because for the majority of patients, we're talking about chronic serious mental health, recovery over a very long period, and the management in the community, sensitive, caring, management of the community within the conditions will be appropriate. And of course, those who manage the patient can always apply to the Secretary of State to reduce the condition. So it's not as if they're completely fixed, that they are subject to a continuing duty by the Secretary of State to be able to change. So that package we submit satisfies the winter work requirement for a review at reasonable intervals. I next turn to the part 3 of my submissions concerning the common law interpretation of section 73. And the first issue to focus upon, and like the Court's attention, is the meaning of the word discharge in section 73. And broadly, the rival contentions are these. The appellant, we submit that discharge in section 73 means discharge from detention at a named hospital as authorised by the statutory scheme under the Mental Health Act. That's paragraph 31 of our case. The Secretary of State submits that in this context, discharge from detention means discharge from detention or liability to be detained, and accordingly the imposition of a set of conditions which continues to deprive the patient of their liberty is not a discharge within the meaning of the Mental Health Act, and that's their case at 25.3. Now, the term discharge is not defined within the Mental Health Act, but section 23, which is not in your Lordship's and Ladyship's bundle, I'm afraid, but is an additional page which we put in this morning, is helpful in understanding the meaning, the wider meaning of the word discharge.
Do we have it?
We have it in a separate electronic file.
Page.
Your Ladyship,
And it appeared in
should
an
be on
email
the
this
Ladyship's
morning.
table, but we can provide another copy if it's not.
Is it from subsection 5 onwards that you want to refer, Mr. Law?
Well, my Lord, it's substantially section 23.1 to which I was.
Oh, right. Well, unfortunately, the electronic file starts at section 23, subsection 5, but Don't worry, we've got it in email.
My Lord,
An email this morning.
that's 22, my Lord.
is
23
it?
starts at the bottom of the page.
Oh, I see. Oh, right. Hang on then. Quite right.
My Lord, Section 23(1) provides, subject to the provisions of this section, sections 25 below, a patient who is for the time being liable to be detained or subject to guardianship under this part of this Act shall cease to be so liable or subject if an order in writing discharging him absolutely from detention or guardianship is made in accordance with this section. And then the section provides for the ways in which a patient can be discharged from either detention, guardianship, or a community treatment order under section 23(1)(a). So at least in section 23, a person who is discharged does not need to be in a prior state of detention, because you can be discharged from guardianship or discharged from a community treatment order. Further,
Sorry, say that again. You can be discharged from a guardianship
guardianship
or a community...
or community treatment order.
That's 1A, is it?
It is, my Lord, yes. So, further, a person who is on Section 17 leave from a hospital, who's been granted permission by their responsible clinician to live outside the community, which in practice will in many cases be the circumstance in which a patient lives prior to discharge, will not at that point in fact be detained, be living in the hospital. They are a person who's not detained, but they remain liable to be detained.
Leave of absence.
Because leave of absence could be cancelled at any time. It follows, we submit, therefore, that at least for this part of the Act, the word discharge must mean release from the restrictions on the individual patient, which can be lawfully imposed on the patient as a result of decisions made under the Act. But of course, this section 23 is only concerned with absolute discharge, not conditional discharge, because it doesn't apply to restricted patients. But the approach we respectfully submit to discharge in the context of absolute discharge is consistent with section 72. If I can take the court to section 72, which is MS 224. That is concerned with the discharge of a patient who is liable to be detained under the Act, section 72(1)(a) and 72(1)(b). And therefore that also covers the situation of a patient who is not in fact detained at that point because they're granted section 17 leave. Thus an order under section 72(1)(b) has the practical effect of removing the possibility that the patient will be required to return to detention, and if their mental health deteriorates, a fresh process has to be gone through under the Act. The responsible clinician cannot simply recall them to hospital. So a discharge order made by the Tribunal under section 72 releases the patient from liability to be detained at a named hospital, irrespective as to whether the patient is in fact detained at the hospital at that point. Now, of course, a conditional discharge is not an absolute discharge, and the power of the Secretary of State to recall a restricted patient remains if you're conditionally discharged, and therefore the patient remains liable to be detained within the meaning of the Act. And I'll take the court to the PH decision, where that was the decision of Mr. Justice Elias, which we submit was plainly correct. But before then, can we go to the decision of Mr. Justice Mann in the Mersey Regional Health Authority case, which is Volume 2, Tab 20, MS 1035. This was a case concerning 2 conditional discharges under Section 73, and one of the conditions set as a conditional discharge for Mr. Studdard was that he should receive further treatment at a different hospital, a sort of halfway house arrangement, to prepare him for a community placement, which was accepted by everyone to be sensible. The only question was whether it was within the powers of the tribunal to order as part of a conditional discharge. But if I can take court to 1178D, MS 1043, the learned judge said as follows: the word discharge, as employed in section 72 to 75 of the Act of 1983, means, in my judgment, can only mean release from hospital. The release may be absolute or it may be conditional. And then a few sentences lines down, a condition requiring the patient who is conditionally discharged should remain in hospital is, in my judgment, inconsistent with the duty to discharge, albeit conditionally. That decision was analysed by Miss Justice Elias in the PH case, which is Volume 1, Tab 3, MS 285. And
Tab 3.
Sorry, Volume 1, Tab 3, 285. And at paragraph 28, the judge confirmed that a patient who is conditionally discharged remains liable to be detained, which we submit must be right.
Well, I'm not entirely sure what that is. That's a debatable proposition.
Well, my lady, I'm quite happy to debate it, but for present purposes, that may...
Assume it to be right for the purposes of your argument.
I'm grateful.
So which paragraph is it?
Can we invite your ladyships to paragraph 30? And can I invite the court to read paragraph 30?
Started at 28, didn't you?
Yeah, I started at 28 for the proposition that Lady Hale raised a question mark about.
Well, quite, I just want to see what it is. Plain from section 41(3)(a) that a patient who is only conditionally discharged remains liable to be detained. Accordingly, discharge is from actual detention rather than from liability.
And then paragraph 30, my lord and ladies. The judge went to the decision of Miss Justice Mann, and if I can invite the court to read that paragraph. And the key sentence is the one beginning, the central issue, it seems to me, is whether or not the conditions constitute a continuing detention. Now, we submit that that passage contains 2 unstated assumptions. The first is that the condition-making power given to the tribunal in section 73 contains the implied limitation that the conditions could not continue any form of deprivation of the patient's liberty. And that assumption is neither contained within the express words of section 73 or is necessary for the working out of the statutory purpose. And secondly, that this implied limitation was necessary to give effect to the convention rights of the patient. And we submit that neither assumption is in fact appropriate or justified, because Parliament gave a wide power to set conditions as part of conditional discharge regime, which will inevitably place restraints on the patient's freedom, usually operating in circumstances where the patient will be living outside a hospital. And as Mr. Justice Holman explained in the case of SH, which for your note is Volume 3, Tab 30, MS 1294, at paragraph 17 and 18, Section 73 is general and open-ended, and there are no express words in Section 73 or 75 or elsewhere limiting the scope or effect of any condition which may be attached. So the limitation does not appear on the face of Section 73. Secondly, the conditions give legal authority to the staff at a community placement to impose the restrictions consistent with their conditions. Hence, for example, the outside door can be locked. But the statutory framework, but that's consistent with the statutory framework to manage the risks presented by both the patient and the public arising from the patient not being detained in hospital, and thus facilitate the discharge of patients to other than the hard core. Because the context is important, the power of recall exists, but the combination of the assumptions made underlying this paragraph thus requires more patients to be detained in hospital where liberty is more constrained than if the implied restriction was not present. And we respectfully submit that the analysis of the problems of this paragraph by Lord Justice Carnworth, as he then was, and His Honour Judge Sycamore in the Upper Tribunal case in the Secretary of State for Justice and RB are compelling. That's volume 3 at tab 31. MS, starting at MS 1314. And the analysis starts at paragraph 38. Or if I can invite the court to read those 4 short sub-paragraphs.
Where do we find that? What's
MS 1324, my lady, sorry. And we submit that there is a compelling logic to the observations of the court at between paragraphs 50, or the Upper Tribunal, between 50 and 54, which I invite you to read at some point, but just for present purposes, 53, MS 1327, the premise for the exercise of the tribunal's powers is the patient has previously been lawfully detained, so Article 5 has been complied with, but he does not now need to be detained in a hospital, and that some other form of accommodation is appropriate, subject to the possibility of recall. The next step is to devise the conditions. At that stage, it's hard to see why the question of whether the conditions would amount to a detention for the purposes of Article 5 should come into it. Even if they do amount to such detention, there will be no breach of Article 5 because the 1983 Act makes provision for the procedural safeguards guaranteed by Article 5. The tribunal's concern should be simply to decide what is necessary for the well-being and protection of the patient, the protection of the public, and satisfy themselves the patient is willing to comply with the conditions and that to the extent consents to them. We see no reason why Parliament should have wished to concern themselves with the fine distinctions which may arise under the Strasbourg case law on detention. The PH decision itself shows how narrow the dividing line may be, and indeed that the issue may not be capable of final decision at that stage. It's surprising that a matter going to the jurisdiction of the tribunal to make an order should depend on not solely the terms of the conditions, but how they're implemented. In conclusion on this point, we do not think we're bound by the Court of Appeal decision in PH or the High Court, cases which followed it, to hold, contrary to our clear view to the effect of Section 73, the validity of the conditions proposed by the first-tier tribunal depends solely on whether or not they amounted to detention. a tribunal's finding that a care home, not being a hospital, is an appropriate place for the patient's accommodation subject to conditions is enough to give them jurisdiction and indeed require them to direct a conditional discharge. We respectfully submit the logic of that is compelling. Those arguments were not accepted in the Court of Appeal, and if I can take the Court to Bundle 1, Tab 5, the judgment of the Court of Appeal in RB, and invite the Court...
Sorry, the reference again.
Bundle 1, Tab 5, MS 320, and the key paragraphs are paragraphs 48 and 53. Paragraph 48 at MS 339. Where in my submission, the court asks the right, Lady Justice Arden writes, asks the right question but reaches the wrong answer. 48, in my judgment, the core issue of this case is whether there is any statutory authority for deprivation of liberty once an order for conditional discharge has been made. The correct answer we submit is that that's contained within the condition-making power in section 73. And then to 53, down that page, 339, at the end of the day, however, I accept the submission of Mr. Chamberlain. The original order against RB authorised and authorised only detention in a hospital. That's right. But it doesn't tell you about the court's power to then make further arrangements going on that appear to the tribunal to be appropriate. The question really is how much liberty is given back to the patient. And the fact that Section 73 does not expressly provide that conditions can be set, provides expressly conditions to be set, but doesn't expressly say those conditions can deprive the patient of his liberty, must at best, we submit, be neutral if it's necessary to fulfil the statutory purpose to deprive somebody of their liberty, and that's contained within the wide powers. The concern at paragraph 55 that the purpose of Article 5 is to avoid arbitrary acts by the state, in my submission, does not arise because the tribunal is not making arbitrary decisions, it's making carefully calibrated decisions for which it gives reasons and for which there is an appeal to the upper tribunal. And that therefore must remove any question of arbitrariness.
Well, looks, doesn't it, as if what the Court of Appeal was worried about was that it was completely open-ended, the terms of Section 73 permitting conditions, and this is what Lady Justice Arden says in 54, isn't it? It's not enough that the patient is given the right to apply to court if he doesn't know the legal basis on which he could lawfully be subjected to an order for conditional discharge to an institution other than a hospital on terms that he continues to be deprived of his liberty. What she seems to be worried about is that there are no criteria, no rules.
No, well, Your Lordship's right, but in fact, my submission that in circumstances where, as explained in the upper tribunal, the success or otherwise of a conditional discharge regime requires on the cooperation of the patient, whether the patient's got a consent or not. In practice, it requires the cooperation of the patient. The cooperation of the patient is the protection against arbitrariness. We're talking about circumstances where the patient wants to be discharged, wants to move to a lower level of restriction, accepts that this is the next stepping stone towards discharge in the community, has an incentive to be discharged, and those decisions are made after an open hearing in a tribunal, in a judgment where reasons are given, and where there's a possibility of an appeal. So, in my submission, that's more than sufficient not to say that this should be used as a reason to restrain the powers of the tribunal and prevent them doing precisely what the tribunal and the patient think is appropriate.
I think what's said against you is that that's maybe fine and dandy if what is happening is a progression from a detention in a hospital to some lesser form of deprivation of liberty. But I think what's said against you, amongst other things,
Many things said against
is that there's nothing to stop the tribunal, if you're right, imposing conditions which amount to a greater restriction on the patient than the present regime in the hospital where he's currently at.
To which the answer, my lord, in practice is that patients are not purely passive recipients here. If the patient is refusing to consent to the regime, then sooner or later the patient will be recalled to hospital and resume the less restrictive regime. Alternatively, if the more restrictive regime is an essential stepping stone to reintegration into the community, in an individual case, that may well be justified because the longer term aim is to reintegrate these patients into the community. And therefore, in the process of doing so, restrictions have to be imposed on them. And the extent of those restrictions must be case sensitive, depends on the individual case. But that is not going to be the vast majority of cases. That's not this case. It's not any case of which there's any example.
If the restrictions imposed are the greater, there's an absence of corresponding protection, isn't there?
There is, my lord, but there would also be an absence of proportionality if they weren't justified, and therefore they wouldn't be conditions that could be lawfully imposed. Because the conditions have to be proportionate to the risk presented by the patient.
I had in mind in particular the ability to apply for variation of the conditions.
Yes, well, my lord, except that it's...
Notwithstanding that the conditions, that the restrictions are greater, there's a longer period before the application can be made.
There is, my lord. The window is extended, and when the patient and those representing the patient have to make the decision, in effect, do we agree, do we consent, do we sign up for this treatment plan? One of the things they're signing up for is a less frequent review. But as part of the overall package, the vast majority of cases, they will be on the route towards what they achieve, what they want, which is a community placement. And if the patient says, yes, that's what I want, then the statutory, and the tribunal thinks that's appropriate, and it may well think it's not appropriate if the restrictions are too onerous. But if the tribunal thinks it's appropriate, then that's the exercise of the tribunal's judgment in trying to move the patient on away from hospital, away from the hardcore that are going to be treated in hospital, towards, on a stepped basis, towards freedom in the community.
Would it be open to a tribunal, I mean, it may be irrational, but would it be open to a tribunal to say, we think actually the regime this chap's operating in at X hospital is really pretty thin. What he actually needs is rather more severe containment.
My lord, it would be open them to make recommendations.
No, why can't they simply discharge conditionally on terms that some greater containment is imposed upon him? Can they do that or not?
My lord, I think that's theoretically possible, but one always has to bear in mind the supervision of the Secretary of State in these cases.
He could do the same if it's right.
Yes, it's not the experience of most people who work in this area of an over-liberal approach by the Secretary of State.
No, I'm not contemplating it. I'm contemplating a rather illiberal. But I mean, it may be, I suppose, that if you're right in starting with Lord Bingham's postulation about the purpose of conditional release, that in order to be lawful, a conditional release has to be aimed at advancing the treatment of the patient.
My Lord, yes, I think that must be right. And it's identifying those hardcore who can only be treated in hospital, who will have to stay in hospital, at least with their present risk profile and condition.
And I appreciate that you're asking us to accept that the norm is that the conditions are a halfway house,
Yes.
or at least a part-way house. What I'm trying to tease out is whether there is actually anything which requires that to be so.
Well, my Lord, the statutory purpose, I think, is how I would say that the statutory purpose is not to try and encourage greater confinement. It's to progress the encouragement of liberty in as much as it's consistent with managing the risks to the patients themselves and in particular the risk to the public. But, my Lord, what we submit is that neither judgment addresses the question as to why it should be assumed the wide condition-making power given to the tribunal should be subject to the implied limitation. And the flaw in our submission is that these judgments treat discharge from detention under the Mental Health Act and deprivation of liberty under Article 5 as if they were the same concept, but they're not. Discharge under the Mental Health Act means removal of the lawful restraints imposed by that statutory scheme. Deprivation of liberty within Article 5 can arise in a whole number of different occasions. And in any event, a conditionally discharged patient is not entirely discharged from a liability to be detained because he's subject to the power of recall.
I've checked section 41.3a, and I withdraw my comment about PH on that, in that respect.
Lady. Lord, therefore, for the purposes of this court, we submit that when the construction exercise is taken purely on common law basis, there is no reason in common law terms to impose an ECHR type restriction on the wide powers to set conditions. And the question of how the impact of the ECHR impacts on that, I'll come to in a moment. But in pure common law terms, these are wide powers, and the restriction doesn't exist on the face of the wording of Section 73 and is inconsistent, we submit, with the statutory purpose. Because it inevitably leads to circumstances where the tribunal thinks it would be appropriate to discharge into these types of into community placement with these conditions, but the implied restriction prevents it being able to do that and therefore prevents it being able to do its job. Can I next turn to the impact of the European Convention on the statutory construction exercise? There are three central concerns that imposing the restriction on the types of conditions a tribunal can impose under Section 73 causes issues as far as the Convention is concerned. The first problem is that there is no deprivation of liberty if the patient consents. So the proposed conditions, and so the article rights of the patient are simply not engaged. The second problem is that interpreting the statute in this way restricts the powers of the tribunal, and that breaches both the Article 5 and Article 8 rights of the patient. And the third is the discriminatory position between the patient with capacity and the patient who lacks capacity.
The Article 5 and Article 8 rights of the patient.
Yes, Article 5 and Article 8 rights, for the second point, my Lord. And the third is the discriminatory position between capacitors and non-capacitors. In considering the impact of the Convention, can I invite the Court to pick up Bundle 1, at MS 282, the Convention rights are set out, but in particular it's Articles 17 and 18 which are helpful at page 5 of the... It's the convention right set out in Schedule 1. It's page 5 of Schedule 1. And if I can invite the court to read 17 and 18. Whilst in some ways these are the statement of the obvious, they do, in my submission, remind the court that convention rights exist for the benefit of citizens, for individuals, and therefore statutes should be interpreted in a way which promotes those convention rights rather than seeks to restrict them. The consent issue, in my submission, falls into 3 parts. First of all is Article 5, engaged in circumstances where a patient provides a valid consent. Secondly, how should the tribunal respond if consent may not be real or may be coerced? And thirdly, what happens if the patient changes their mind? The first point is consent engaged. Given the time, I'm going to take this very shortly and simply submit that the case of Stork in Germany makes it entirely clear that a mental health patient who gives valid consent cannot have their Article 5 rights breached. And for your note, that is the second period of detention in the Stork case, at paragraph 102, MS 529. And the court concluded if there was consent a fortiori, there could be no deprivation of liberty within the meaning of Article 5.1. That was followed in Stanev and Bulgaria and was summarised in Cheshire West. And if I can invite the court to Cheshire West, I appreciate the court will be very familiar with this case. But in summary, it's at Bundle 1, Tab 6, MS 344. And the essential characteristics of a deprivation of liberty were identified by the judgment of Lady Hale, with whom Lord Sumption agreed, and with whom Lord Carr subsequently agreed. Paragraph 37, MS 365, and it's an essential element of any deprivation of liberty, that the subjective component of lack of valid consent.
Sorry, which paragraph is it?
Paragraph 37, my lady, MS 365.
Yep.
So, my lord, my ladies, if there is valid consent, then Article 5 is not engaged. Accordingly, we submit there's a conceptual problem in imposing a restriction on the condition that a tribunal can set as part of a conditional discharge by limiting them to avoid a deprivation of liberty, when by definition, where there is consent, Article 5 is not engaged. Therefore, the proposed limitation, based on the need to avoid a breach of Article 5, by definition, doesn't arise. It solves a problem which doesn't exist. And this issue was considered by the Court of Appeal in the B case, which is Bundle 1 at MS 320. And in particular, at paragraph 90 of that decision, I'm sorry.
I don't think there is a paragraph.
No, there isn't. terribly sorry, I haven't got a note in my...
Give us a couple of phrases and we'll be able to find it.
My Lord, the case referred back to the decision of HL and said that in HL the decisions were...
54.
It is 54, yes, I apologise. 54 MS 340. My notes have let me down. But referred back to the argument being that the liberty rights are too important for a person to lose the benefit of the right because they've given themselves up to be taken into detention. And whilst that's plainly correct, but I invite the court to draw 2 points about that case. I won't take you to HL. HL is very well known as the Bournemouth case. Firstly, HL was a case about a patient who never had capacity and therefore by definition could never have given consent. And secondly, the key words about giving up is a reference to the De Wilde case, and we submit that's about an entirely different factual and legal situation, namely whether a person who voluntarily goes into custody loses the right to later change their mind. And we deal with those cases and the run of cases on De Wilde at paragraph 56 of our case. And if I can take the court to paragraph 56 of our case, which is MS 55. And for present purposes, I'm simply going to ask the court to note that these are a series of cases, Wilde, Oshipeno, and II, all of which were concerned with the same issue, which was whether at the point that a person gives up their right to liberty voluntarily, they then lose it entirely. And what happened to Mr. De Wilde was he was a vagrant. He was a member of the French Foreign Legion and a labourer, ran out of money, presented himself at the police station, said, I haven't got any money. He was therefore imprisoned as a vagrant. He then tried to escape and was recaptured and returned. And the question was whether or not his liberty was, he was deprived of his liberty, to which the answer the court gave was, yes, you are, but under the Belgian system for dealing with vagrants, there's a scheme, it's compliant with the Article 5, 1E, and therefore there's no breach. And the other cases, Oskipenko and II, are similarly. My learned friend makes places considerable store by a recent case called Buzjardi and Moldova, which is at volume 1, tab 13, MS 600. And this is a case about a Moldovan businessman who was arrested on corruption suspicions and made repeated applications to have his for bail, which were refused, and then asked to be given house arrest. He then was given house arrest, and the question was whether he continued to have his liberty deprived when he was under house arrest. And if the court would be kind of turn to paragraph 108, MS 624. It was held that even though he'd asked for house arrest, that didn't prevent lack of deprivation of liberty, because it was under coercion, we see from lines 4 and 3 lines from the bottom, a clear state of duress. So what the court is doing is saying consent must mean proper consent, not consent extracted by coercion or duress, which we accept.
Why is it different? it is asked of you. For the mental patient who's under detention in hospital, doesn't like it, and the only way he can get out is to agree to some other form of detention.
Because, my lord, he has 4 options. He can offer active consent, proper consent, and the tribunal are very experienced at judging whether there's proper consent, because if there's not proper consent, it's not going to work. If it's not going to work, there's no point in doing conditional discharge in the first place. Secondly, he can actively oppose the conditions, which will show that he's not cooperating with them, but he could argue...
So could Mr. Basaji, presumably.
Yes, in which case he would have remained in prison. Remained in prison in circumstances where that, as the court subsequently found, was a breach of his Article 5 rights.
Oppose the conditions, anyway.
His third option is to argue that he should be subject to a conditional discharge, but for less restrictive conditions. And his fourth is to argue for an absolute discharge. So he has a series of options open to him, with the decision maker who's having to make a risk-based assessment of the most appropriate way of managing the patient. Further, my lord, most patients before tribunals have the benefit of legal representation. And therefore the question as to whether the consent, any consent that's offered is real, as opposed to being under duress, is, in my submission, something which can properly be examined. But at the heart, my lord, is this point, which is a choice between tough choices does not remove consent. A patient who has cancer and has to make the choice between chemotherapy, radiotherapy, or no treatment, a shorter life but without the side effects, has no good options. But that means that the consent process has to be carried out more carefully, but the lack of a good option doesn't remove consent. This is not Hobson's choice. As the court may be aware, Mr. Hobson ran a stable in Cambridge, and because he wanted his horses circulated, he only ever allowed you to take the horse, if you wanted a horse, which was next door to his office. So the choice was that horse or no horse. That's not this case. This is not Hobson's choice, which is no choice at all. There are a series of choices. But if obviously the patient will have a better chance of securing a conditional discharge if the patient actively indicates to the tribunal that he or she will cooperate and is determined to make a success of it. But that doesn't remove the possibility of success, of there being in my submission, doesn't remove or necessarily assume there is either coercion or duress. On the contrary, the tribunals are very well aware to avoid that issue. So we submit that the argument that there is no scope for consent for mental health patients, which is the decision of the Court of Appeal in this case, simply doesn't fit. It's a breach of the Article 8 rights of the patient. The patient has the right to have their consent. And there must be, in our submission, scope for a mental health patient to offer genuine consent, because if genuine consent is given, Article 5 is not engaged, so the Article 5 problem, deprivation of liberty problem, never arises. And we submit it would be a breach of his Article 8 rights to remove him from the possibility of being able to give that consent. And if that's right, the problem that the restriction seeks to meet falls away. And it would therefore be illogical for the court to interpret a statutory interpretation exercise to put limitations on the powers of the tribunal when that limitation may not be necessary.
Is the election to choose one of a series of unpalatable options or choices, is that synonymous with consent?
It's not synonymous with consent, but it is often the backdrop against which the consent decision is taken. The consent decision has to be taken between the available options open to a patient.
If I am presented with a series of choices, all of which I find more or less unacceptable, and I go for the least unacceptable, can I be said to be truly consenting to that option?
Well, my lord, the answer is that if all the options are unacceptable, it is perfectly open to a mental health patient to say, I choose none of them.
Oh, I appreciate that.
In which case there is no...
That's not the premise on which the question is asked.
If what the patient is saying is, I have to choose between these options, or I may choose between these options. I don't have to make a choice, but it's in my interest to make a choice. I'm therefore making a choice. I'm making a choice between options. My lord, similar circumstance arises where housing authorities faced with homeless people who then say, here are a choice of 3 properties which we will provide to you as the council to discharge our duty under the Housing Act. None of them are very attractive. In fact, almost by definition, they will all be unattractive options because you're entering into the housing market, they are the least attractive. But if a person in those circumstances does not choose one of the options, that extinguishes the duty of the public body.
Well, I don't know that that's a good analogy, because surely it's not a prerequisite for the discharge of the housing authority's duty that there be a valid consent on the part of the person to whom accommodation is offered.
Well, no, my lord, but it's an analogy to this extent that the patient is being offered by a public body a series of options. They're not obliged to choose any of those options, but if they don't choose any of those options, their situation may get measurably worse.
Can I just explore, if it were to be Hobson's choice, properly so described, then would it be a real enough consent or not on your case?
My lord, my lady, it depends on... Hobson's choice can become a real choice, but the tribunal would have to be extremely mindful as to the question as to whether there was duress or coercion.
Right, because it does seem to me that in certain circumstances it is Hobson's choice, because if you discard the last 2 of your potential courses, asking for an absolute discharge and wanting less restrictive conditions under the conditional discharge, because they're not practical on the facts.
They may not be practical on the facts.
Then if the patient wants to ride at all in the Hobson's choice situation, that is to say, wants to get himself out of hospital, he's only got one choice.
My lady, if the circumstances are that arguing for less restrictions is not practicable, which there may be cases where it is, there may be cases where it isn't, and that's a judgment that would have to be taken.
Well, this is a case where it looks as if it isn't it?
Yes, it may well be. If there's only one
So take this case.
Yes. In which case the patient does have one option to sign up to or not to sign up to as part of the discharge, the next stepping stone away from hospital. And the patient therefore does have a real choice between, do I want to actively say, yes, I'll go for that option, because it's better for me, it's a state of lesser restriction, which is of course the case here, or does he say, no, I'm going to take my chance, I'll come back in a year's time, I'll do further work, and the next conditional discharge will create better options. There is a real choice, and even people who only have a choice of one have a choice.
Am I right? Is it still the rule that you can't put a defendant on probation without his consent?
My lord, it's some years since I did criminal law.
Yes, I'm sorry, it's not a fair question.
And
I'm fairly sure it is. And if you're sentencing the small-scale drug dealer, you might find yourself in a position to say the normal sentence for this is going to be, or rather everybody will know what the normal sentence is because it's a term of years. you might be in a position to say, in your case, I'm persuaded, if you consent, that a probation order with a condition of drug treatment is an option. And you have to ask him, don't you, whether he consents or not. Now, if he does, is it a real consent or not?
Well, my Lord, it is a real consent in my submission because it is the exercise of decision-making by an individual, albeit faced with very limited options. And we should not assume that limited options means no option, or that in that situation, the drug dealer does have the real choice of going to prison or facing a regime which he probably will find very unpalatable and very difficult to deal with.
Might, which is why I tried to find one that
Yes.
had some possible bearing. Anyway, all right, that's your
Lord,
answer.
my submission doesn't remove the choice. Difficult choices don't cease to be choices. Can I very quickly, I'm conscious of the time, very quickly ask what happens if the patient subsequently changes his mind? And in my submission, this is actually part of a bigger question for the tribunal, because there is always the possibility of a patient changing their mind, and however strong the consent is given, by definition we have people who are suffering from serious mental health problems. And in fact, the issue is part of an entirely different question, namely, what is the risk assessment that this conditional discharge is likely to be a success? Because if the patient removes their consent and then starts acting in accordance with their removal of consent, inevitably there will be questions about whether the patient should be recalled to hospital. It may happen, it may not happen. It depends precisely on the consequences of and the type of removal of consent. But if, for example, a patient who is under a condition only to have unescorted leave runs away from the escort, that is highly likely to change the risk profile and therefore lead to the patient being recalled, because the escorted leave condition was imposed to protect the public, and a patient who's running away from the escort, inevitably the risk profile changes. But we say that if a patient changes their mind, or the prospect of a patient changing their mind, actually it's just part of the risk analysis, and the whole structure is uncertain by definition. And therefore, that's just one of the factors the tribunal has to take into account of at the beginning as to whether the conditional discharge is likely to work. And then if it happens in practice, they have to deal with it like the care staff and the Secretary of State then have to deal with it like any other ebb and flow or change of circumstance in this very moving picture with an individual who is, by definition, suffering from a long-term serious mental health condition, and therefore the future is unpredictable. It's not in specie different from any of the other unknowns or uncertainties that arise. The second reason that we say that interpreting the power to impose conditions is inconsistent with the ECHR rights of the patient is developed as paragraph 72 to 75 of our case. And I can take this really quite quickly. In order for a detention to be lawful, the detention must be in compliance with the domestic law of the state, but it also needs to be consistent with the principles of the convention and not arbitrary. And that was developed recently in the case of James, which is volume 6, tab 56, MS 2158. And this is a case about the lawful, it's a case about sentences for intermediate imprisonment for public protection. And can I take the court to paragraph 190 at MS 2198? And the court explained the nature of the lawfulness test. 191, 190, where the lawfulness of detention is an issue, the Convention refers essentially to national law and lays down the obligation to conform to the substantive and procedural laws of national law. However, having regard to the object and purpose of Article 5.1, it's clear that compliance with national law is not sufficient in order for a deprivation of liberty to be considered lawful. Article 5.1 also requires deprivation of liberty should be in keeping with the purpose of protecting the individual from arbitrariness. The court has not previously set out an exhaustive list of what types of conduct on the part of authorities might be considered arbitrariness for the purpose of Article 5.1, but some key principles can be extracted. And the principles are then set out in the following paragraphs. And if I can take you to 195, MS 2200, the court explained the nature of the conditions, and what it said is where the detention, in the middle of that paragraph, where the detention of alcoholic pursuant to Article 5.1e is an issue, the court has indicated deprivation of liberty is only justified where other less severe measures have been considered and found to be insufficient to guard the individual or public interest which might be required that the person concerned be detained. An individual cannot be deprived of his liberty as being of unsound mind unless the mental disorder is of a kind or degree warranting compulsory confinement, and the validity of continued confinement depends upon the persistence of such a disorder, and so on. And what we invite the court to draw from that is that there's a need for proportionality between the ground of detention and the type of detention. And of course, in this assumed situation, we're comparing two circumstances, both of which constitute a deprivation of liberty, but one constitutes a higher deprivation of liberty. And the answer given by Malone and friends is that Article 5 is concerned with the fact of deprivation, but not the quality. And we respectfully submit that may have been correct in the past in Ashingdane, but in Ashingdane that was never a point where there were two practical options for the Secretary of State, because he couldn't actually move Mr. Ashingdane to Oakwood because of the strike. And when he could, he did. That case cannot apply to circumstances where a decision maker genuinely has multiple options with different levels of restrictions. And the court has therefore developed the concept of arbitrariness in James to the extent that the quality of the detention and the option for a less restrictive regime could well mean that the more restrictive regime could be characterised as being arbitrary. But for present purposes, we don't need to go that far. All we need to say is the court should not interpret a general decision-making power so as to remove the possibility of a less restrictive regime. And the Secretary of State relies on Secretary of State, Lord Bingham, but we respectfully submit that doesn't help him in this, because his interpretation leaves the hard core, leave patients beyond the hard core in hospital. And so we respectfully submit, following, as set out in our case, that the Article 5 and Article 8 rights of a patient are engaged in this decision-making process and in the interpretation of Section 73, see Muntjaz, and it's a breach of those rights to restrict the options open to the tribunal by an artificial limit on the restrictions that can be imposed. The tribunal should be allowed to decide what is the most appropriate for this patient, as per Lord Justice Carnworth in the upper tribunal case. The final ECHR problem in my submission is Article 14 and the position of patients with capacity as compared to patients without capacity. The question is whether the statutory scheme should be interpreted in a way that the combination of the powers of the Tribunal and the Court of Protection can facilitate the discharge of patients who lack capacity, but cannot facilitate patients who have capacity. And this was considered by the Court of Appeal in this case. If I can take you to it at paragraph 35 of the case, it's Appendix 1 of the core bundle, MS 123. Paragraph 35 clearly envisages that arrangements could be made where a patient who lacks capacity goes to the Court of Protection and says, the Court of Protection, please impose conditions on a deprivation of liberty for me, and then goes back to the Tribunal and says, there's a legal regime that will restrain me sufficient to protect the public, therefore please conditionally discharge me, knowing what the regime is. This issue was considered in some detail by Miss Justice Charles in KC and the Secretary of State, which is volume 1, tab 7, MS 386. This is a case that was in the upper tribunal that considered the issues that we're concerned with today, that was between the RB case in the Court of Appeal and the case. But decision was made, for reasons I'll explain in a moment, by the Secretary of State not to appeal this decision to the Court of Appeal.
It's after RB in the upper tribunal and before RB in the Court
No,
of
it's
Appeal.
after RB in the Court of Appeal, my
Sorry.
Lord. But before the case worked its way through the system. This case concerned a patient who did not have capacity, and Mr. Justice Charles was sitting. I should make it clear, I did this. I appeared in this case.
Just seen that. Can't keep it a secret ever.
My lady, I may explain why I'm here today. But this case concerned a patient who lacked capacity, and the question was whether the judge sitting jointly in the Court of Protection and as the upper tribunal could approve a care plan and exercise his powers under as a Court of Protection judge to impose lawful restrictions on KC which were sufficient to meet the public concern and therefore to allow him to be conditionally discharged. And in summary, Ms. Justice Charles decided that they were. The judge correctly analysed the different regimes of the Mental Health Act and the Mental Capacity Act, as well as identifying the role of Court of Protection in authorising a care plan which contained restrictions which deprive P of his liberty. And we see that at paragraph 33 of the judgment. The judgment is not entirely straightforward to follow. But paragraph 33 paragraph 41.
33.
Yeah, it can't be 43. Paragraph 41, MS 401. Where the difference was quite correctly summarised. In contrast to the Mental Health Act, the Mental Capacity Act does not contain express statutory powers to detain a person for defined purposes. Rather, its approach is to authorise deprivation of liberty if it's in the best interest of the relevant person, and so is the least restrictive options available to them to provide the relevant care and treatment in the best interest of that person. The position of the Secretary of State in this case, which is different to the position today, was the Court of Protection could impose more extensive conditions than were permissible by the Tribunal, and thus a patient who lacks capacity could effectively be managed in the community by a combination of the restrictions imposed by the Tribunal and the restrictions imposed by the Court of Protection. And we see that...
Hold on a second. Restrictions imposed by the Court of Protection, it's authorising.
Yes, it's authorising a care plan, my lady.
But it's authorising a deprivation of liberty, not imposing it.
Yes, it's authorising it, my lady, yes.
That's different, isn't it?
I'm sorry?
That's different, isn't it?
It is different, my lady. It is subtly different. What the Court of Protection is doing is saying, in order for this patient to be discharged, this is the proposed care plan with all these restrictions. Is it in the best interest of this patient to be subject to those restrictions which deprive him of his liberty? Is that in his best interests?
It's fine, but the power of the Court of Protection to authorise in the best interest of the patient isn't much use unless the Tribunal has power to impose them in the first place, is it?
Well, my Lord, the position of the Secretary of State before the upper tribunal in this case was that a care plan could be proposed which had greater restrictions than the tribunal could direct, but nonetheless the Court of Protection could take the view that it was in the best interest of the patient to be subject to those restrictions because it would facilitate a discharge from hospital. And therefore...
But if the Tribunal can't make those conditions, how does it help?
Because, my Lord, what happens is that, take unescorted leave, if the condition that the Tribunal cannot impose is unescorted leave, because that deprives him of his liberty, but the Court of Protection says, here is a care plan which provides for no unescorted leave, we approve that. Therefore, the staff are therefore lawfully able to prevent him having unescorted leave. It must be always escorted leave.
The condition simply says comply with the care plan, does it?
Yes.
That's the dodge.
That's the dodge.
Yes, I see. All right.
And the dodge, the position before the Secretary of State, if I can take your lordships to, for the judge, was at paragraph 62, where he rightly identified that the concerns were MS 406, that the question of what conditions were appropriate in the public interest was for the tribunal, not for the Court of Protection. And clearly that's right. The Court of Protection is only concerned what's in the best interest of the patient, of P, whereas the tribunal rightly has to look at issues of public protection as well. But we submit that that concern, in fact, is slightly misplaced because it mistakes the identification of appropriate conditions, which is a matter for the tribunal, what conditions should be imposed, with the power to authorise a care plan, which in effect imposes those conditions, which is, on this analysis, for the Court of Protection. And once that distinction between identification and authorisation is identified, the concerns raised by the judge fall away, and therefore it's perfectly appropriate in these. If this restriction exists, it's perfectly appropriate for the tribunal to say, for a conditional discharge, these are the conditions which would have to be imposed, including no escorted leave, for example. But we can't impose that condition. For the Court of Protection to say, we have to take what's decisions in the best interests of P. It is in the best interest of P to be discharged. He will be in a situation of less restriction than being in a hospital. The only way that's going to happen is if there's a care plan which has no unescorted leave. Therefore, that's in his best interests. and therefore we approve the restrictions in the care plan, which because that plainly is in his best interest, because in reality the other option is he stays in hospital. So that's perfectly okay, the distinction between identification and imposition. That then means that if this restriction exists in the powers, statutory powers of the tribunal under section 73, nonetheless, patients without capacity have a route to being conditionally discharged, and patients who've got capacity can't. And in my submission, that constitutes a breach of Article 8, Article 5 rights combined with Article 14. The answer from the Secretary of State is to argue, contrary to the way the Secretary of State put his case in KC, that the regime of the Court of Protection should not be used to impose wider conditions. It seems to me that falls foul of the distinction between identification of conditions and the power to impose conditions. It must be for the tribunal to identify what conditions are appropriate, but once they're identified, it's plainly for the power for the Court of Protection to say that's in the best interests of P, so that doesn't work. Secondly, the Secretary of State argues that the capacitous and incapacitated patients are not in relevantly similar positions, and we say, why not? They're patients who both have long-term mental health problems. They're both subject to the same statutory regime under the Mental Health Act. They both have residual ECHR rights. They are, in my submission, plainly in analogous positions. And thirdly, there is a weak and somewhat unsubstantiated, in our submission, unsustainable argument to suggest that a difference in treatment, a difference of options, is justifiable. Simple as that, it can't be justifiable. Why should the statutory scheme provide options that will allow a patient without capacity to move into a lesser degree of deprivation and get on the way to community placement, but to deny that to a patient with capacity? So the key question in our submission remains whether it's consistent with the patient's human rights to impose a limitation on the condition-making power under Section 73, which prevents a patient with capacity being moved to a less restrictive regime, when the apparatus of the state can properly be used to facilitate that move for a patient who lacks capacity. And we say that's a plain breach of the capacitous patient's human rights and is the mirror image of denying the patient the right to consent. Because what the tribunal, what the Court of Protection is doing is taking a best interest decision for those who cannot, by definition, take the decision to consent. And therefore, if the Court of Protection can do that, in our submission, the patient ought to be able to do that themselves. And therefore, once you've got that position, there simply is no justification for imposing the restriction to say that the wide condition-making power under Section 73 is subject to this wholly unsatisfactory limitation, not on the face of the statute, that it can't be used unless the liberty that's given back removes the deprivation of liberty. Unless I can assist the court more, those are our submissions. I've strayed 10 minutes into my learned friend's time, I think.
Well, we strayed rather a lot into your times. I feel sure it can be made up in some way.
Unless I can assist, if there are any questions, I can assist further. Those are my submissions.
I think not. Thanks very much, Mr. Lott. Mr. Patrick?
my lords, I'm going to
It's
address
nice to see you on your feet, Sir James.
the luxury of sitting for the last 2 days. That's the right way of describing it. My ladies, my lords, I'm going to address you, if I may, under 3 heads. The first is going to deal with issues relating to the interpretation of the statutory scheme, and they're obviously a bit related, or quite more than a bit related. The second is going to be under the heading of consent, which will obviously have to drift in to some extent to the Article 5 case law. And the third is going to be the consequences if the Court of Appeal or the Courts of Appeal are right on their issue of interpretation, because it's contended against me that there would then, as a consequence, be a breach of Article 5, 8, 14, and so on. So those are the three headings. And if I can move straight to interpretation, it may be helpful, because I'm going to try and do it principally by reference to the judgments of the 2 Courts of Appeal who have considered the issues that arise before the court. It might be helpful if you had before you, in addition to the core volume, where you have the Court of Appeal in MM, in the usual place in Appendix 1, starts at MS 116. But if you have that in hard copy, they place considerable reliance, as you will have seen, on the earlier decision of the Court of Appeal, the judgment of the court being given by Lady Justice Arden, and that is in Bundle 1, Tab 5 of the authorities behind at page 320 in the MS numbering. But I'm going to try and do most of it by reference to that. You have a collection, and perhaps the most convenient collection, of the relevant provisions in the statutory scheme in the earlier Court of Appeal judgment in B, where they've quoted extensively, or Lady Justice Arden quotes extensively from the legislation. There's a much crisper summary, in effect taking those quotations as read in the MM Court of Appeal judgment, but those are the 2 principal Court of Appeal judgments that I am defending, in a nutshell. The interpretation issue, then, if I can turn to that, and we make 8 short points in relation to that. The first is that the original hospital order only empowers detention in a hospital and not elsewhere. And if you have the MM Court of Appeal judgment and you go to paragraph 19 of that, 1.9 of that on MS page 120, they placed some weight on the location of that power, as in located in the courts to make a hospital order under sections 37 or 41.3, as tending against, so the location of that power tended against, in their view, some form of general implication of power in the FTT, the different body, at the conditional discharge stage derived from the scheme of the legislation. But the original hospital order made by a court is only to detain in a hospital order, with restriction orders then sitting alongside it.
Oh, the court can't discharge the hospital order.
It can't.
So I don't quite see that the FTT can discharge.
The FTT can, but all that this leads to is that you've got to look somewhere else in the statutory scheme to find a power to detain somewhere else if that's what you're looking for.
The court, when it makes the hospital order, launches the chap into the statutory scheme, which includes the tribunal's power to make a conditional discharge.
It does. But this is an example. It's a stepping stone, perhaps, to the second point,
yes,
which is that where you do have powers to detain in the legislative scheme, and where the power is intended to confer a power to detain, they're clearly set out. And the primary powers are in Section 3 and Section 37. Those primary powers sit alongside a variety of ancillary powers, and I can perhaps take that most conveniently from our case. If you go to our case, core volume MS page 91, paragraphs 32.2 and 32.3, you have there collated, I hope conveniently, the collection of other powers, ancillary powers relating to detention. And again, all of them is the common theme, clearly and specifically set out in the legislation, when that is Parliament's intention. And as the Court of Appeal in the case rightly noted at paragraph 16, there is what they described as a critical distinction in the legislative scheme throughout that combination of provisions between detention in hospital, liability to detention in hospital when conditionally discharged, reflected in the power of recall, and the other one they referred to, which is also referred to in those paragraphs of our case, 136, for example, the holding provision, and any other deprivation of liberty. So there's a distinction between those three concepts running through the legislation. Thirdly, we've drawn attention in our case to section 117. That's at paragraph 31 of the case, if you still have that open. And it's a short point. But it does suggest, and it's suggestive rather than, as it were, a bull point, but it is a suggestive point, the language and the structure of 117, as you see from our case at paragraph 13, in relation to aftercare services, is premised on leaving hospital and ceasing thereby to be detained. It suggests, as it were, that Parliament had the binary situation in mind, detention in hospital or not detained. So we say that's the underlying premise of 117. That's the third short point.
Have we got 117?
Yes, it's, I think
it's fully set out, is it, in your
let me just check it.
Paragraph
It is, it's
31.
in bundle 1, tab
No,
1,
it's not.
232, I'm grateful.
No, it's not fully set out.
Thank you.
Well, you can remain in hospital not detained.
You can. That
That's
was the, yes.
Very common situation.
Yeah. The fourth point.
I'm sorry, Sir James. What's the position of the what I'll call the non-criminal patients, the what used to once upon a time to be called section patients, section 3 patients, who are moved by their responsible clinicians onto community treatment orders? Are they still detained or not?
They probably wouldn't be.
I think they are. They're liable to be hauled back.
Yeah.
And indeed by the clinician rather than anybody else, I think.
Yes, they could be. I mean, I confess I haven't delved into all the intricacies of their position, but you'll recall that in the Court of Appeal judgment, PJ, which was the second half of the judgment, was an example of that ilk.
I think that's right.
And he was detained.
PJ was on CTO.
Yeah.
Yeah.
He was detained pursuant to under CTO, and they considered whether that was authorised under the.
I was just trying to apply my mind to your binary proposition that it's either in or out, as it were, and I just wondered about the community treatment people. Anyway, we'll come back to that.
Well, it can't be entirely binary, as I pointed out, because you can be
isn't
detained in hospital but not detained, and you can be out of hospital.
You can, but it strikes you or not as binary in part, perhaps.
Yeah.
Fourth proposition is that 73.2 is therefore the only place in which authority might be found for detention elsewhere. And the first point to note about 73.2 is the one noted by the Court of Appeal in B at paragraph 53, of B, which is that it is wholly silent on that important point, as Lady Justice Arden put it. In other words, it doesn't make any reference whatever to detention otherwise than in hospital. And that led the Court of Appeal in B, just to jump around in their judgment a bit, if you go to paragraph 27 of their judgment on MS 333, that fact led them to the conclusion drawn in the second half of paragraph 27 on 333. So the fact that there is no reference to detention anywhere in either 73.2 or, and I know the court already has this point, in section 42, which confers, as you know, powers on the Secretary of State, including 42.2, to discharge subject to conditions. So what's sauce for the goose is sauce for the gander. The fact that there is no reference in either of those to detention is in itself significant when you're addressing the issue of interpretation for the reason which is given in the second half of paragraph 27 of the B judgment. The fifth proposition is a slightly longer one, or will require a little bit of development. The legislation in 73.2 and 42.2 only makes a general reference to the imposition of conditions, simply empowers the imposition of conditions without more. And we do respectfully submit that that creates a number of real difficulties with seeking to interpret that general power as permitting deprivation of liberty in a place other than a hospital under this legislative scheme. And one starts, of course, with the question of approach. True it is that it's relatively unusual for me to stand here addressing you about the principle of legality in my favour, as it were, but it is a principle of interpretation created by the courts, and as weaponry, therefore, it is in principle just as available to me as it is to anyone else, because it's used as a tool for discerning the proper intention of Parliament, which is ultimately what the issue of interpretation is all about. And we do place reliance upon the principle of legality. And we do so because this would in nature be a general power to impose conditions which would be being interpreted or applied to permit a deprivation of liberty otherwise than in accordance with the express powers conferred in the legislation, which only deal with detention in a hospital. And the principle of legality applies, as you know, not merely to ECHR rights, but also, as this court has very frequently held, to rights which the common law holds as fundamental. And liberty, for obvious reasons, is one of those. And if you still have the B judgment open and you go to paragraph 53 of that judgment on page 340, you will see that Lady Justice Arden and the Court of Appeal there refer not merely to Article 5, which I'll come back to in a moment, but to Magna Carta and the well-known provision in Clause 39 of Magna Carta. But that it applies in that situation and to those common law issues, it is also evident from the recent Supreme Court judgments in B. Algeria. That is in Authorities Bundle 1, tab 8, page 434. And the paragraph I want for this purpose, you see the basic context. I don't need, I think, to go through the facts in the head note, but a quick glance will show you the context. It's powers of SIAC in relation to bail. see my Lady Hale and Lord Hughes and Lord Lloyd Jones were on the court. Paragraph 29 is the one in the judgment of Lord Lloyd Jones, with whom the rest of the members of the court agreed. Paragraph 29 is the relevant one on page 434. And the principle is set out just by the letter E. Common law principle of legality, as it were. And then if you cast your eye a little bit further down, paragraph 29, it's also authority for the proposition, or also makes clear that that principle applies not merely to the executive, but just as much to the interpretation of powers granted by legislation to a judicial body. Here, therefore, the FTT. And what the principle of legality does, as again you will be well aware, is to require clarity and specificity if Parliament is interfering with or overriding that right, or that sort of right. General words are not enough. Indeed, I'm not going to take you to it, but I think we referred in our case to the judgment of Lord Toulson in the ingenious media case at paragraphs 19 to 20, where the court went further and said not merely are general words not enough, quite the reverse. The more general they are, the more difficult it is. More apparently wide they are, the more difficult it is to for this principle not to operate, as it were. So one needs that degree of clarity and specificity. How is that degree of clarity and specificity to be tested? Again, that's been the subject of repeated consideration in this court, as you will all be well aware, and the answer is only if the right is interfered with or overridden by express words or necessary implication. Express words need no introduction, and probably neither does necessary implication, but the case law on necessary implication has moved potentially at least a little bit. My lady gives me the look. It used to be that I used to cite to you Lord Hobhouse in Morgan Grenfell. As you will recall, it's a matter of principled necessity, not just because it's reasonable or the court thinks it's a good idea. A little bit of feathering of that in relation to the prisoner's smoking case, as you will recall, where my lady's judgment...
Well, that's why I'm giving you the look.
You're giving me the look. I realised that was why you were giving me the look. And I'm going to give you in return the citation to my lady's judgment, which is the latest word, paragraph 37 in black, authorities for, tab 37, MS 1531. I never know whether that clock is fast or slow. It was a bit fast yesterday, but...
Well, it's about 1 minute past 1.
That may be a convenient...
If that was a convenient moment for you, it would be a convenient moment for us. Well, we'll hear from you further at 2 o'clock and hope that we haven't taken up too much of your time with our own business.